Hello and welcome to our panel discussion on cannabis in the workplace. As we approach the October 2018 legalization date on cannabis in Canada, many employers are left wondering whether or not they're prepared for this change. This panel discussion is a follow-up to the series of workshops hosted by the Saskatchewan Chamber of Commerce this past spring and brings together the same panel of experts to discuss some of the most important issues employers need to be aware of. Joining us today from Miller Thompson LLP is Amy Grathuis, John Danilou, and from MNP, Janice DeSalle. Amy is a civil litigator with a focus on labor and employment law, providing preventive employment advice to clients on their rights and obligations regarding employment standards, occupational health and safety, human rights, and workers' compensation. John is an experienced labor and employment lawyer who advises provincially and federally regulated employers in both the public and private sectors on a wide range of matters including employment standards, human rights, employee discipline and terminations, and workplace safety. Janice is a chartered professional in human resources and a senior consultant in the consulting services practice of MNP. She has a wide range of experience including performance management, workplace learning, staff development, recruitment, career development, and change management. So thank you to all of our panelists for joining us here today. Let's start with the legal perspective. Many employers in this province are concerned about what cannabis legalization means to their workplaces. And so Amy, from a legal perspective, what are the most significant issues for employers to be aware of in the face of these changes?
Thanks, Kevin. In some respects, nothing is changing. Employers are still required to manage impairment in the workplace, just as they always have. But it is an opportunity for employers to ensure that their workplace policies are really meeting best practices. So, to that effect, employers who have very up-to-date, robust workplace policies regarding impairment or fit-for-work policies may not have too much work to do. Similarly, employers who to this point have been relying on blanket zero-tolerance policies regarding drug or alcohol use in the workplace may need to update or modify their policies to reflect recreational cannabis's legalization. We do note that medicinal marijuana has been legal in Canada for almost 20 years with the appropriate authorization. But still, we should look at the policies with a view to legalization of recreational cannabis, and what we're really suggesting is a focus on impairment as opposed to the specific source of impairment. For many of us, or for many workplaces, what may actually be the biggest adjustment is seeing a shift in perceptions among workers that sees it more acceptable to talk about the use of recreational marijuana, to be open about its use in a way that's very similar to recreational alcohol consumption. It may take employers just a little while to accept that their employees are, on their off time, consuming recreational cannabis.
And I think, too, what we need to do to build upon what Amy said is that we've got to sort of take a breath and think about this a little bit logically before we press the panic button. What still is the case is employees are not going to be allowed to be at work impaired. And that's really the bottom line. And so as a workplace, and as Amy mentioned, having those policies tight enough to be able to control that is what's going to be important for workplaces to take a look at. And so having those good impairment policies, those good accommodation policies, those are part of the toolkit. And the other thing to think about too is when it comes to recreational use of cannabis, when it's not medically supported, cannabis use is not going to be allowed. And so you're going to need to make sure that you also have things like progressive discipline policies in place and processes that are really strong there so you can deal with the behavioral aspects of cannabis use in the workplace.
Janice, let's talk a bit more about impairment. From a policy development point of view, what are the most important things for employers to consider when addressing impairment in the workplace?
Well, Kevin, when you think about policies, policies are really those things that outline the expectations for behavior in the workplace. It's kind of like the rules for the workplace. And so when it comes to an impairment policy, I think the first place an employer needs to look at is what is our definition of impairment? Do we have one? Do we need to redefine it? Right now, a lot of the policies that are in place may be related specifically to drug and alcohol. And so the impairment might be related to alcohol only. And so now you may need to look at that in terms of recreational cannabis and what does it mean to be impaired by cannabis in the workplace. So that's the first thing, is looking at definitions. Then the other thing from a policy perspective is to think about how are we going to define what the observable behaviors are in the workplace. How do we know if somebody is impaired? And so employers may want to indicate in their policies things like, we're going to be looking for observable behaviors of impairment, which may include poor coordination, glassy eyes, or even some personality or behavioral changes in an individual that fully will sort of outline what people will be looking for from an impairment perspective. So that's the second thing. Policies also need to clearly state what's going to happen if somebody is impaired in the workplace, what's going to happen immediately, and then what's going to happen after the fact, because there might be actions that are there might be actions that will take place, maybe corrective or maybe accommodation actions, depending on the situation. And so the policy should outline that. And the other thing with policies, when we're looking at that, they need to be explicit enough, but also broad enough to allow consistent follow-through for all situations. So that's a little bit of a balancing act. And finally, all your supervisors, all your managers, and maybe even employees need to be trained on how to identify impairment in the workplace. So there's a lot of things and a lot of weight the policies carry, and that's why it's so important for employers to have them up to date and solid and ready to go with this upcoming legalization.
Interesting perspectives on policy development. You talked about definitions, consequences, consistent follow-through, and then bringing people together to provide the adequate training and awareness around that. John, at the spring sessions, we heard a lot from employers about blanket zero-tolerance policies. After all, wouldn't they be easier to enforce? Can an employer require drug testing and terminate employees who fail them?
Well, Kevin, there are a number of legal pitfalls with zero-tolerance policies. First of all, drug testing is only permitted for employees in safety-sensitive positions. So a policy mandating testing of all employees would be difficult to enforce. Testing employees who aren't in safety-sensitive positions, such as office employees, is not typically viewed as reasonably necessary for safety purposes in the workplace. And then we have the limitations of current drug testing methods. There are currently no tests that tell us whether somebody is impaired. They only tell us if somebody has used recently. So this could mean an employee could smoke marijuana Friday after work and test positive on Monday. Employers don't have the ability to dictate what employees do on their own personal time, unless that's going to affect their ability to do their job. If we simply terminated an employee who had a positive drug test, likely a court or an arbitrator would find that there's no just cause for that termination.
And also, Kevin, when it comes to zero tolerance policies, they're really ineffective when it comes to dealing with somebody who has a disability. So when you're trying to accommodate somebody who has a disability, you need to be able to accommodate to that particular situation. So zero tolerance means zero tolerance, and it does not allow you to do that. And so we also need to remember that addiction equals disability. And so if somebody has been deemed and found to have an addiction to cannabis, for example, there needs to be work to accommodate that disability in the workplace. And the zero tolerance policy isn't going to allow that to happen.
Janice, you mentioned accommodation. This is a very important topic that we'd like to get back to in a moment. But before we do that, I'd like to understand more about safety sensitivity, John. And so, Amy, how is safety sensitivity defined in legislation or in the regulations?
That's certainly an interesting question, and to my knowledge at least, there's no one national definition or standard for what constitutes safety sensitive. However, the Canadian Human Rights Commission has provided what I see as a really useful definition. I'll read it. They define the term safety sensitive position as one which, if not performed in a safe manner, can cause direct and significant damage to property and/or injury to the employee, others around them, the public, and/or the immediate environment. I like the scope of that definition because it really captures that it's not limited to one specific work site or one specific worker, but looks at the potential for injury or damage to essentially everything around that worker. And of course, while construction sites or a mine where heavy machinery are operated would certainly be captured, I think in practice that definition can be applied to a much broader sector of industries, manufacturing, and certainly would capture quite a number of work sites, especially in Saskatchewan.
Now, Janice, how does an employer determine which jobs in their operation are safety sensitive? And a secondary question to that, can an employer classify all their jobs in their operation as being safety sensitive?
Well, I think as John mentioned, it would be kind of silly to classify all jobs as safety sensitive. It doesn't really make sense to do that. So it would be important for employers to conduct a risk assessment on their jobs. And the risk assessment really helps identify what risks would be around that particular job and the function of the job that that employee would be responsible to undertake in the workplace. So as the definition that Amy read to us, it looks at sort of around the whole employee. So what's going to happen, to the worker, to their co-workers, to equipment, to the public, those kinds of things need to be considered. It's important to conduct risk assessments on each of the jobs to identify safety sensitivity. And so it looks at the nature of the job, the industry itself, and the effect that that work has on the employee, the operations, and the environment around the employee, as Amy mentioned. And so you need to look at those types of items. There are 4 steps really to a risk assessment. And so the first one is to identify those jobs that are going to be analyzed. So you need to look at your workplace and decide which ones may have some safety sensitive nature to them. Then you need to break those jobs down into steps or actions. And then you do a bit of an analysis in terms of, what is the potential for risk at each of those steps or actions of the job. And then finally determine what are the things that we can do to minimize the effect of the actions or the steps at that point. And so that's really how you would go about conducting a risk assessment.
Interesting how an employer can follow a 4-step process to identify, safety sensitive roles and for their operation. Now, John, you spoke briefly about drug testing and some of the limitations behind it. And drug testing was a very hot topic during our spring sessions that we hosted with the Sask Chamber. So under what circumstances can an employer require a drug test? And what does a positive drug test tell us? And what can that information be used for?
Well, Kevin, because current drug testing methods don't actually tell us if an employee is impaired, an employer has to be able to show that there's a reason to send an employee for a drug test. Generally speaking, there will be 3 situations in which an employer can justify sending somebody for a test. If they have reasonable cause to suspect the employee is impaired, so that might mean they've observed something about that employee's behavior or condition that suggests to them they may be impaired by something. Where there is a workplace accident or near miss, and there's a suspicion that potentially drug or alcohol impairment may have played a role in that accident. Or if an employee has been off work to seek treatment for a dependency and is returning to work. In that situation, an employer can require the employee to pass a drug test before they do come back. On the other hand, random drug testing is generally not permitted because in that case, the employer can't demonstrate that there was a need to send that specific employee for a drug test at that time. So your policy is going to be very important here because it will set out for employees and your managers as well when and how a test will be conducted and what will happen in the case of a positive test. So you asked what the information from a drug test can be used for. Really what you get is a piece of information that you're going to use, a piece of the puzzle, a piece of evidence to confirm an employee's impairment. That coupled along with the observations of the employee's behavior, other conditions of the employee will be what you use to build your case to prove somebody's impaired.
Now, we've talked a lot about cannabis, and I'd like to shift gears here a bit and talk more about impairment again. And Amy, since health and safety is a shared responsibility, do employees have to disclose that they have been prescribed a medication that can cause impairment?
This is certainly a question we've had from employers a lot and repeatedly. And I think it's fair because employers They're tasked with the responsibility of maintaining a safe work site. They're the ones who, generally speaking, have more resources, have more control over the work site, and have control over employees. So as we know, the standard that are placed on employers is quite high. So we get the question, well, what about the workers? What about the employees? Don't they have to be part of this? Don't they have to tell us? And it certainly is a really good question. The short answer is yes, employees do have a duty to disclose. The Saskatchewan Employment Act, under the Occupational Health and Safety sections, do place on employees a positive duty to take reasonable care to protect the workers' health and safety, as well as the health and safety of other workers who may be affected by the workers' acts or omissions. Because the duty to disclose is not explicitly set out in the legislation, and because we're reading into or interpreting this part of the Saskatchewan Employment Act to confirm that there is a duty to disclose, this is why we advise employers to include in their workplace policies very explicitly the obligation to disclose whenever a worker is consuming any substance that may cause impairment, and that would even include over-the-counter medications. It may not be intuitively obvious to a worker that they should disclose this, that they should tell their supervisor or their manager that they're taking something that may cause dizziness or drowsiness, but it's another example of clearly setting out your expectations for your workers and making it easy for them to follow those expectations.
And Janice, you touched on dependency previously, and I'd like to go back to that topic. And so what does an employer do when something like this comes to light, when a worker discloses that they have a drug or alcohol dependency issue?
Well, I think the first thing that you need to do in these situations is to determine whether or not this is a temporary situation, such as Amy mentioned with the prescription drugs for a period of time, or if this something is a little bit more long-term, like a dependency. When somebody comes to you and says they have a dependency on some substance, and we'll use the example of cannabis, at this point, you do not have to take their word for it as the employer. You do need to work with the employee and their doctor to validate the situation, and then you'll go from there. And so that's where the accommodation policy comes in, and that's why it's so important to have one of these in your toolkit along with other policies. An effective accommodation policy is going to outline the purpose of the policy, it's going to outline who it applies to, it's going to outline things like definitions that are pertinent to understanding of the policy. Along with this, the policy should outline the responsibilities of the organization, the supervisors, and the employee in relation to the accommodation situation. And most importantly, the accommodation policies should also have those procedures in there to be able to explain what is going to happen now. I've declared a dependency, or I've declared an accommodation is required. What's going to happen next? So that the policy has those accommodation procedures, how to appeal an accommodation, and also any privacy and confidentiality measures that are going to be put in place. Now, if you aren't familiar with accommodation policies, the Canadian Human Rights Commission has a fabulous resource on their website in the What is the Duty to Accommodate section on developing policies. So it's something you may want to take a look at if you don't have an accommodation policy and want to see what that might entail or what that should look like. So I would suggest doing that. So there are some important things to remember when it comes to accommodation. And the first thing is accommodation is based on the employee's particular situation. And so when it comes to an accommodation plan, it's going to be tailored to meet that particular employee's needs. And it's very important at the same time to document the roles, responsibilities, and expectations for the employee and as well as the organization during that accommodation. The second thing to remember about accommodation is that an employee needs to understand who do I go to ask my questions about the plan. So the employee should have one person to go and speak to about their questions or concerns throughout the process. The other thing is that when it comes to accommodation, it is very consultative. So the employee's involved, the organization's involved, their medical team is involved. But the thing to remember here is that the employee doesn't get to choose what their accommodation is. As the employer, if you have a certain job that is not the employee's normal job or even not at their regular rate of pay, the employee doesn't get to choose. You as the employer have made the accommodation, and they need to take what there is available to them. And the final thing is, when it comes to accommodation, it does continue until the point of undue hardship.
Interesting, Janice. So when it comes to accommodation, undue hardship is a topic that's commonly referenced. John, can you explain what undue hardship means from a legal perspective?
Yes. The term undue hardship is defined in the Saskatchewan Human Rights Code. In terms of employment, it is an intolerable financial cost or disruption to the business. But what does that really mean? So factors that will be considered in determining whether there is undue hardship to an employer have developed over time in human rights case law. Basically, employers are required to take all reasonable steps to find alternate duties or revise schedules or any other actions that would allow an employee who requires accommodation to perform meaningful work. Mere inconvenience to an employer does not amount to undue hardship. Safety concerns, disruption to the workplace, availability of meaningful work are all things that will be considered. Employers aren't expected to displace other employees from their jobs to find an accommodation for an employee with a disability, nor are they expected to create a new job for that person. The size of an employer will also play a role in this. A very large employer with multiple departments and a lot of different jobs will have a higher expectation that they're going to be able to find something that this employee can do. Whereas a smaller employer with less variety may have more difficulty in finding an accommodated position.
Janice, you mentioned the consultative process to accommodate an employee. Therefore, through the process of accommodation, what kind of information can an employer ask for, and what is an employer not entitled to know?
Well, when it comes to accommodation from an employer perspective, it is more about prognosis and not diagnosis. So what that means is the employer is not entitled to know what condition or disease the employee has, but rather what impact that has on the job. And so basically it means an employer has the right to know what can this employee do and not do, because I need to know that so I can accommodate or make accommodations for them. You also have the right as an employer for updated medical information along the way throughout an accommodation, so that you can understand when things can change in terms of the duties, for example, or the length of time that somebody's at work as the situation improves.
Amy, can you comment on the relationship between the employer's duties to provide a safe workplace and the duty to accommodate and the individual's right to privacy?
Kevin, I feel like this question really hits the nail on the head. This is the issue. There's so many moving parts when employers are thinking about impairment in the workplace, how to address impairment in the workplace, how to identify it. And really, the three issues that you've just noted are all constantly moving pieces. So it's not possible to give just one simple, straightforward answer on this. It's always going to be a balancing act. However, I do think that there are two primary considerations or two primary points that I'd make. The first, as I mentioned, is this type of balancing. Employees do have a right to privacy, especially over drug tests results, confidential medical information, accommodation plans. So employers have to be aware or be thinking about these types of privacy issues anytime impairment or accommodation becomes an issue in the workplace. Second, as Janice mentioned earlier, there always needs to be a certain amount of discretion in the workplace policies for how that balance can be struck. The reason that this is so important is because, quite aside from any employment law considerations, the Saskatchewan Human Rights Code has fairly significant remedies in terms of cost awards for employees who file a complaint that's upheld. So, for example, employers can face orders to reinstate an employee, to pay any lost wages or benefits for any period of time that they were off, as well as an order of up to $20,000 for injury to dignity or hurt feelings occurring as a result of the breach of the Human Rights Code. Breaches, of course, would result from the lack of accommodation, an accommodation plan that wasn't properly implemented or followed, and things of that nature. As John mentioned earlier, the duty to accommodate is very high, and it's something that can continue and would require revisiting as medical or other circumstances involved. And I think that when we're trying to balance, to try and play these three issues, look at them together, privacy considerations, workplace safety, the duty to accommodate, employers have to appreciate that it's going to be an ongoing and evolving process.
We have heard the legal perspective on workplace policy development. Janice, can you comment on the role that workplace policies play in this relationship as well?
Well, when it comes to workplace policies, they outline the expectations of behavior in the workplace. And so that's the main purpose of them. Policies should also outline the consequences of not following policy and should clearly stipulate what's going to happen in those cases where people are in contravention of the policy. And when it comes to having policies, it's great if an employer, you've got them, but then the important part is to make sure your employees understand them so that supervisors are very clear on what their role is, employees know what their expectations are, and so that they can abide by those policies in the workplace. And finally, it's one thing to write policies and to have them and to communicate them, but the enforcement is also important as well, and consistent enforcement of your policies is also key.
We've heard a lot today about the legal and HR implications related to cannabis in the workplace. Any final thoughts before we wrap up our discussion today?
Yes, with recreational use of marijuana just around the corner, now is really a great time for employers to review their drug and alcohol policies, or if they don't have one currently, to develop that policy. We don't know exactly how legalization is going to impact employers. We don't know exactly what this means in terms of the increase in drug use and potentially impairment in the workplace. But the best starting point to be prepared for an employer is to have a good policy in place, just in case that situation arises.
It really is an opportunity for employers of any size and regardless of the sector they're in to take a good look at their workplace policies and ensure that they meet best practices.
And from an HR perspective, I think it's important that we remember to not forget what we already know. We already know some things. We already have dealt with different kinds of impairment in the workplace. And while it might be a slightly different situation with the legalization of recreational cannabis, there are some good things we've already learned. So we need to look to those learnings, at the same time recognizing that we are entering a new normal and that having this conversation now ahead of the actual legalization date, we're making some assumptions and bringing in the information that we already know to sort of get a plan of attack in place. Next year, if we have this conversation, we might have some new lessons to share. So it will be an ongoing process, and I think it's important to remember that we still know a lot of stuff right now, so we've got to use that knowledge as we move forward.
Well, thank you again for being here with us today and sharing your knowledge and expertise with Saskatchewan employers. To our viewers, you will find a transcript of this panel discussion on the WorkSafe Saskatchewan website, followed by a number of resources to help you deal with impairment in cannabis in the workplace.